Welcome. Let's give it some time to have some folks join, and then we'll get started with our Challa weekly webinars. And today we're going to hit some of the new updates that have immigration updates since our last webinar, and we'll do Q&A at the end. And as always, please post your questions in the Q&A box and not in the chat box. And depending on how many people we have joining us today, we may limit the questions for each person so that we can get to everyone's questions on the webinar. So first, I'd like to wish you all a happy St. Patty's Day. You know, I wanted to talk about that in the context of all the hate crimes we're seeing against the API community. And the reason is there was a time where America was not so welcoming to the Irish immigrants as well. There would actually be signs up saying, no Irish need apply. And yet we are now celebrating St. Patty's Day. So that has been the unfortunate history of the United States, is that with each immigrant community, whether it was the Germans, the Italians, the Latino community, and now with all the rhetoric about the pandemic and the origins of it, now the animosity towards the Asian community has surfaced. But this is who we are as a country, the celebration of the diversity of what the United States provides. And you can still be an American and celebrate your culture and your diverse background. And so that's what today means to me. So without any further ado, let's get started with our weekly webinar. So as always, I always start out reminding you all to connect with me. I love to hear from you. And there are different ways in which you can connect on Facebook, Twitter, Instagram, YouTube, of course, and LinkedIn or our Telegram group. And we'll talk a little bit about the Telegram group at the end. But these are ways in which you can get the latest updates, and you know, I can answer any of the questions that you have, and you know, you can be equipped to take charge of your immigration journey and your immigration objective. You can only do that if you've got the information, and that's what we are here to provide for you. If you have missed any of our weekly webinars, please take a look at the YouTube channel. We've got a lot of interesting information on the YouTube channel. Information about the Child Protective Act, postings for, you know, if you're working at home. We've had some questions where there's some companies that are saying, hey, I can't file an H-1B for you or an E-3 because you're working remotely and we can't post at home. That is incorrect. So take a look at the chock full of information that you will find, and I try to go through it meticulously so that you can understand each issue we talk about, whether it's downgrades or how to create a good perm job description. So if you like what you hear on our YouTube channel, then please subscribe, comment. I like hearing from you, and share it with your friends so we can grow the community further. Today, we're going to cover immigrant visa processing, interview waiver eligibility, national interest exceptions, the April Visa Bulletin, and the prevailing wage rule, which has been delayed, public charge rule, USCIS reconsidering some H-1B denials, and a CAP registration reminder. So that's what we're going to be covering today. So Department of State updates. Now, you know, everyone is familiar with the Department of Homeland Security, right? But the way it is structured jurisdictionally, that means who has the authority over. Anyone who is outside the United States, the jurisdiction or the authority of those people is through the Department of State. So, the visa processing, the immigrant ban, there are two bans that were put forth, the non-immigrant ban, which will expire the 31st of March, and then the immigrant ban. And so the immigrant ban has been, removed or revoked. So the Department of State has announced additional information involving that rescission. They said individuals who received a final refusal on or after January 20th, 2020, due to the proclamations, can seek re-adjudication without resubmitting their application or forms or paying additional fees, provided that the underlying visa petition remains valid. And denials may also be reconsidered, but new applications and fees are required. On March 2nd, the Secretary of State rescinded 4 categories of individuals and their dependents previously eligible for the national interest exception on the health-related ban for the Schengen area, United Kingdom, Ireland. And the categories rescinded are as follows: that technical experts or specialists, senior level managers and executives, treaty trader and investors, and professional athletes and their dependents. So if you are from those countries where there's a health-related ban, but you fall under these exceptions, and you'd still be able to seek visa processing through national interest exceptions. And previously issued national interest visas will not be revoked, but changes are effective moving forward. The list of critical infrastructure sectors have been updated, and there is the list, and travelers in academic, student, or journalist categories remain eligible for national interest exception as well. The State Department also continues to offer national interest exception for public health, national security, and humanitarian categories. Policy allowing individuals to apply for a non-immigrant visa in the same category and forego the interview. This is the Dropbox, people who are eligible for the Dropbox. Previously, it was available with those who expired 24 months. And it's the discretion of the consular officers to grant an interview waiver. But, there are many people who, if you were seeking the same visa classification at the same country, then you were eligible. And so now they've expanded it. And you can take a look at our website for more information on Dropbox eligibility. In April 2021, Visa Bulletin is out. It was released earlier than it has been the past few months, and the USCIS has not announced whether they will accept the filing date or dates for filing yet. And this is just a reminder that it's only when you file an adjustment for the final action date that it freezes your child's age for CSP purposes. But we've given you a tip that if you must file on dates of filing and not for the final action date, a thing you can think about is filing a new I-140, because that will actually add on the CSP age. So that's something to think about. EB1 is current for India. EB2 advances 3.5 months, and EB3 advances 3 months under the final action dates. There's been little movement on the family-based charts. So here are the final action dates for the family-based chart, and it's unfortunate that we don't see more movement. On the employment-based, You can see that there is some movement. And now let's go to the Department of Labor prevailing wage rule. This was pursuant to strengthening the wage protections for temporary and permanent employment of aliens, certain aliens in the U.S. Remember, President Trump always wanted to use aliens. He didn't like the word foreign nationals. So that's why you see the word alien there. So the wage rule originally was implemented in October. Prior to the notice comment period, it was implemented as an emergency rule. So they didn't even, they're supposed to, under the Administrative Procedures Act, provide notice and receive comments from people. And then they modified it and published it on January 12th. And DOL stated that the rule was to protect similarly employed U.S. workers. But they delayed the effective date till May 14th, 2021. And remember, the Biden administration is kind of re-looking at all these rules that were implemented previously. So we have to, we'll have to wait and see if they do anything before the effective date. Now, strengthening the wage protections for temporary workers, what they did was the current levels are at 17 percentile. So the October rule was at a 45 percentile, and now they've put it at a 35 percentile for level 1. And as you see, it just increases as you go down. If you have an extension that you need to file, either on an E3 or an H-1B, this may be a good time to do it before the wage rules, the new rules come into play. Remember, you can only file 6 months in advance because you can't file an LCA for greater, but it may be a good idea to file that now. Or if you're looking at hiring, employers can file LCAs now. They don't necessarily have to use them, but they can file it in advance of the new wage rule coming into play. The final rule, like I said, adjusts level 1 and level 4 downward a little bit. The changes of how the data is used from the Bureau of Labor Statistics. And there's a phase-in approach, 4 steps over 3.5 years. So entry-level wage should look to the wages paid to U.S. workers who possess a master's degree and limited work experience. And the DOL, DHS rules will focus on the high users of the H-1B program is what the focus is. So USCIS, yay, the public charge rule. Remember, there was a lot of litigation going back and forth about the public charge rule, and it finally went up to the Supreme Court, and the Department of Justice said that they would not defend the 2019 public charge rule, so they're no longer applying it. I know that there's been so much back and forth on this rule. And in fact, there were some I-485s that were filed within the window where there was a stay on the public charge rules that was filed without the 944, and USCIS rejected it. So this may be a way in which you can take this rule and refile and say that, further that they should accept your I-485. 11 state AGs are arguing against removing the public charge rule, but I don't think that it will gain any traction, hopefully. So the USCIS is going to reconsider denied H-1Bs that were denied pursuant to, remember, the specialty occupation and some of the other issues that were the employer-employee relationships that were where a federal court had stated that the USCIS unlawfully, was enforcing those regulations. So they will use their USCIS can use their discretion to accept motions to reopen if it's filed more than 30 days after this decision, if it's filed before the end of the validity period requested on the LCA or petition. And the decision was based on policies rescinded in the H-1B memos. So if you have been denied an amendment or an H-1B extension based on that, this is a good time to go ahead and try to file a motion to reopen. The 3 rescinded memos are determining employee-employer relationship, including third-party placement, contracts and itinerary requirements, and involving third-party work sites. Remember, I've talked about it last week. It's not, the standard is you have to show sufficiency of work. And so it is not, as long as the work is not speculative, but it's anticipated, then your H-1B should be approved. And the guidance on H-1B computer-related occupations, the degree requirement. So if it was rescinded on any, if you've got a denial based on any of these, you should request a motion to reopen. The USCIS notes that the agency has discretionary authority to consider untimely motions under certain circumstances before filing, considering the time remaining on the validity period. But even if you filed an appeal, I would try to get an expedited motion to reopen on those types of cases and cite how it was unlawfully denied because the federal district judge had deemed that policy unlawful at that time. This is a reminder that the H-1B CAP registration is open. So if you have not initiated or you know somebody who needs to initiate it, this is the time. The registration period is from the 9th to the 25th, so there's still time to file. And you will receive, the notifications will go out on the 31st, and April 1st is the earliest date at which to file. We've got previous recordings on what you need to do to prepare for your CAP registration. So please visit the YouTube channel with the H-1B CAP webinar. Email us at info@challalaw for a guide for petitioners on H-1B CAP registration. And remember, the deadline is just around the corner, so you still have time. So in crafting your strategy, we talked about a couple of things. We talked about how the wage rule is going up. So if you're going to start your perm or you have an extension for your E3 or your H-1B in the next 6 months, within the next 6 months, this is a good time to start before the new wage rule gets implemented. If anyone has been denied an H-1B, either amendment or extension based on the 3 federal court cases that I had cited, and you still have validity on the H-1B petition, it's a good time to file that motion to reopen. Even if you have an appeal pending, motion to reopen may be adjudicated much quicker than the appeal. The Challa Chats forum, like I told you, we have a forum on Telegram where, I sometimes will chime in to answer questions, but a community that has similar issues, just like you do. So, people are talking about when they're getting their, fingerprinting done, when they're getting their work authorization. You get some great insights. And because it's moderated, unlike other forums by an immigration law firm, if there's any rumors that are out and about that are not correct, we step in to, provide the correct direction, which you will not get in other forums. You have to pay for it. Here, we're doing it for free, and we're doing it truly as a public service. So if you haven't joined our Challa Chats forum, please do that. We have one for H-1Bs and H-4s and one for E-3s. And my team will put up the links. Join, share it with your friends. And like I said, I use the information on this when I talk to communities, when I'm talking to Congress or when I'm talking to, I'm on the immigration task force for the new administration, when we're giving out suggestions or ideas on how to do things better, I take note of all the things you all are talking about on the forums. But if you don't join, if we don't have enough people, that's the way you can create a strong voice. So please join, and like I said, share the links with your friends. Connect with us again. This is just a reminder on Challa Law. Look at some of our previous webinars. I think people have said that they're really helpful, and that's truly the objective that we have. We hope that you will use our services, but even if you don't, I want your immigration journey to go well. And so that's why we've put forth these various platforms so that you can meet your immigration objective. Remember, that's what makes America great. And if you have, after the webinar, if you think of a question and you want to reach out to us, email us at info@challalaw.com. The info email goes to a number of people. So that way you're ensured that your question will be answered. So email us, let us know if there's certain topics you'd like us to cover on future webinars. We're happy to do that. And like I said, please share with your friends. And so just to reiterate, our Q&A portion, please put your questions in the Q&A box instead of the chat box so that we know we can get to everyone, and we'll have Shaker Challa join us in a second, who will be moderating the Q&A section.
Hello, Lakshmi. Good afternoon.
Hello, and happy St. Patty's Day.
Happy I have the mouse pad.
Yeah, the green mouse pad.
I didn't wear anything green, but anyway, happy St. Patrick's Day, everybody. Be careful if you are going out to party.
Well,
Not going out, that is good.
I'm not going out anywhere.
To start with, better for this year. All right, let's see what's happening in the Q&A. Well, let's look at the first one is from an anonymous attendee. When will the new wage rule be in effect?
I think we said May 14th. We talked about it earlier in the webinar. So my tip to everyone is, whether you're an E3 or an H-1B, you probably want to, and you're going to expire within 6 months, you probably want to go ahead and get your H-1B filed. And employers can actually file LCAs now in anticipation of hiring someone down the road. So you have a certified LCA with the current wage.
All right. I see a question on the chat, but so I'm request, please put your questions in the Q&A box. Easy to track, and I will try to attend the one that is in the chat in the chronological order. So let's look at another one. Are there any considerations? 485 interviews will again be waived like it used to be before. So now that
they are talking about that. So we may see that employment-based interviews, as long as I think if I-45J wasn't submitted, they may ask for that, and if that is present, they may go ahead and just waive them.
Okay. Next, AA is asking, hi there, what are thoughts on how far beyond the Visa Bulletin for Indians will go by end of this fiscal year and next year based on last year and this year's spillover? Man, you got to hire a forecasting expert and some forecasting techniques and tools.
Yeah. If I knew the answer to that, I'd have to have some sort of magical, crystal ball to look into. But so we have to just wait and see.
All right. Let's take this question from the chat. Since I said I'll take it in the chronological order. Hi, madam. My I-140, I-485 whole packet is rejected with reasons incorrect fees. We are 100% sure checks were sent. My attorney has shared the copy of scanned copy before submitting USCIS. Now, what are the options left for me?
Well, if it was erroneously rejected, you can ask them to receive it now as if, it's called nunc pro tunc, as if it was received timely at the date of filing. Your attorney would just, submit proof that the checks were in the original filing and state that it was probably a error at the lockbox, and the checks are running around somewhere. You may want to put a stop payment on the old checks, and even though you submit proof that checks were submitted, refile again with brand new checks.
Well, I don't know if they've checked their bank account to see, it's not very clear. It says packet is rejected with reasons incorrect fees. Now, did they get back the checks in the packet? I suppose so. But
no, well, maybe, yeah.
But also, I don't know, maybe a good just to check your online bank account and see,
Yeah, because it's strange that they would say incorrect fees instead of saying that they were no fees.
Exactly.
So you may want to ensure that the correct amount was listed.
All right. Once again, please post your questions in the Q&A box and not in the chat. Sri Kumar is asking, applied AOS EAD AP in October, do not have a valid visa. I plan to travel to India immediately after giving my biometrics and before receiving my EAD AP. My spouse is planning to ship the EAD AP combo card to India. Can I come back to US using that EAD AP card? Will the EAD application be denied if I leave the country even after giving the biometrics?
Previously, in the previous administration, during the Trump administration, they'd taken the hardcore platform that if you leave before the AP is issued, they would not process the AP. They'll process the EAD, but not AP. And so if they know that you have departed, then there is a chance that could happen. Now, if your H-1B is expired visa, but it's expired within the period that's now allowed, then you may be eligible for Dropbox.
All right. Srinivas Vitla. I asked the same question. It's not clear. Currently, my status is F1 STEM OPT and valid until June 2022. And visa on my passport got stamped until July 23. I applied for H1 this year for 2022 quota. If my H1 picked through lottery on next month, April 2021, then I'm planning to go to India in June 2021. Can I go to India using my EAD if my H1 got picked on April 1st? My OPT is valid until June 2022, also visa stamped 2023.
If you depart the United States while a change of status is pending, you would have deemed to have abandoned your change of status. So until it's adjudicated, until it's approved, you should not depart the United States.
So Srinivas, what she's saying is, if you get picked in the H-1B lottery, don't go, right? Is that what you're saying?
Yes.
Yeah, till you get the approved, and once he gets the approval, then he can go. Even if he's not going to work from October 1st, right? Doesn't have to wait till October.
Well, he can continue working on his STEM OPT. The other thing you can do is if you're selected, you can if you do consular processing, then you can travel without any problem to your H-1B. You can do that. So, you know, there would be a lot of things I would think about before doing that. Like, if you're leaving in July, when are you coming back? And do you want to continue working on your STEM while you come back? And then how are you going to process in October? Now, you can go to Mexico to process your H-1B visa, because remember, it's consular processing, it's not change of status. So those are some things you can think about as you're making your decision.
All right. Manish Agarwal, I see your question on the chat. I'll take it up and in the right order. I just wanted to let you know. Next question is an anonymous attendee. What if you are filing for permanent residency? Is there time to get that in before the wage rule changes?
Well, you can try. I'd have to go back to look to see if it's applicable, if because for the last time the wage rule changed, they said even with those prevailing wage requests that are pending, they would apply the new wage rule. I have to check to see if they would do that here, or the mere fact that you filed prior to kind of secures the, you know, the current wages.
All right. Prem Pathak is asking, the new H-1Bs will fall under the new wage rule?
No.
Okay. Why is there an increase in the wage levels? That's the question from an anonymous attendee.
Well, they deem that the wage levels as it's structured now does not truly reflect what the wages are. So they want to, it's instituted to protect U.S. workers from hiring what they call cheap foreign labor. So it's for protection of U.S. workers.
Okay. Another AA, hi, what's the status about visas for undocumented immigrants, 11 million?
It's still, Congress is trying to work that through. So it's at a standstill right now. Remember, President Biden submitted a bill. There's a bill in the House and there's a bill in the Senate. The issue is, even though the Senate has, remember, it's 50-50, it's, you know, with the tiebreaker being the vice president, it's, you know, you've got a strong Democratic pull. For most bills, what the opposing party can do is they can filibuster it. So if they filibuster it, it can just go on and on and on without a vote. In order to overcome a filibuster, you need 10 additional votes. So they would need 60. They don't have that right now. The exception to that is if they put it through reconciliation. That means it's part of a budget. And if it's part of a budget bill, then they can overcome the filibuster through reconciliation. So we'll have to see what they're going to do.
Okay. Naveen K is asking, if I have my H-1B extension coming up in November, can I file my LCA now before the new wage level kicks in, and then file H-1B in June, July sometime? Can I file LCA before 6 months of the H-1B expiration date?
Yes, yes, you can. You won't get the full 3 years on your extension, but you can go ahead and have your attorney apply for an LCA now, so you're not subject to the new wage. And that's what we're going to recommend to our clients as well, is not only in anticipation of any extensions they may have, but any new hires. So if you go ahead and file an LCA, you don't need to have a specific person. You have to have a job title, and you have to have you know, a location. But you can do that for multiple LCAs and have them on file.
All right. Let's go to a friend Manish Agarwal on the chat. Once I get the EAD, can I work a second non-IT job, say as a Best Buy Geek Squad or something similar, besides my regular H-1B employer's job?
If you work for an employer other than your H-1B employer on your EAD, you will no longer be in H-1B status. You can do that, but if you want to preserve your H-1B status, then you cannot.
All right. The AA is asking, hello, Lakshmi Garu and Shekhar Garu. My priority date current now, EB3, August 2010. Question number 1. Let's see how many questions he has. 2. Question 1. If the spouse applied I-485 and for some emergency reason she went to India, but in a few days the primary applicant got GC, how the dependent will come back? As of my knowledge, once GC approved, H1, H4 will be inactive, right?
Right. So it happens all the time. So as long as when they come in, what will happen is CBP will look and say, hey, your green card has been issued. And as long as they have a basis for entry, they would just allow them to come in and give them a certain period of time to get that corrected. So it hasn't been a problem.
This question 2 is, if she left after fingerprints and the GC is approved while she's in India, how could she come back?
They will allow her to come back if they see that it's approved. So she would have to have an entry, a basis for entry into the United States. But the CBP will say, hey, when you were out, your green card was approved. And so they probably would just stamp her with a 551 stamp when she enters.
Okay, anonymous attendee, no papers, but I graduated. Can I get OPT to work? That's
Okay.
all.
What does that mean, no papers?
I don't know. And then there's another follow-up. I don't know if it's the same person. Can I get diversity visa if I'm undocumented? That's one sentence from that. And there's another sentence for the previous one. So I'm not sure if, let me request folks, if you don't want to reveal your name, that's fine. We have no issues with that. But I think it'll be nice to formulate your entire query, in one piece and then post it in the Q&A. Put your thoughts together. You're not going anywhere. We are here. Write it down on the Word or whatever, and then copy it nicely and paste it. So that way everything is in one place. So your attorney will know, will get correct information. If you do piecemeal or just like that, it's tough to answer. So I'm not sure what answer you want to give. The first one is, no papers, but I graduated. Can I get OPT to work? Can I get OPT to work or OPT to work? I don't know what that means.
Please email us at info@challalaw.com, because what you're saying, I'm not understanding. So
yeah. The other question is, can I get diversity visa if I'm undocumented?
There's a difference between being undocumented, which means, you can be out of status, or if you entered without inspection. If you entered without inspection, really, unless the immigration regulations change, the issue is not that you can't file for a diversity visa. You can't do anything with it because you can't adjust in the United States.
All right. I see people putting questions in the chat. I'm requesting again to please put it in the Q&A box. Next one is from Raghu Gundaram. It's a new person. Welcome. My priority date, August 2012. He's got 1, 2, 3, 4 questions, or 4 points. I don't know if it's a question. My new I-140 EB3 downgrade is filed concurrently with I-485 on December 14th, 2020. And there was a mistake on I-140 petition with page 6, employer signed, which was in older version date 5/9/2018. And the rest of the pages in new version date 9/30/2020. I think that's the background. Second point, received rejection notice on February 25th, 2021, and returned all the applications along with the fee. Point number 3, now with filing date chart is not being considered, is it possible to refile my I-140 along with I-485? My attorney said they contacted Lockbox, and once they hear from them, they will refile.
Well, once we find out whether USCIS for April is taking either the final dates or dates for filing, you can always refile, especially if they didn't cash your checks, if you're eligible. So I wouldn't wait to, if you are eligible to file in April, I would just do a refile and not worry about trying to get it corrected through USCIS.
Okay.
But maybe you should get another attorney, because that's a pretty big mistake in submitting the wrong form.
Okay, I'm trying to see what Srinath is saying. He posted a question at 12:12. And 12, I don't even see a question at 12:12. The first question is at 12:19. But anyway, Srinath, I'll take yours. Lakshmi Garu, any information about recent I-485 resubmissions after Lockbox rejected due to blanks? Do CIS accepting? That's all he said.
Rejection based on blanks?
Yeah, maybe incomplete information. That's what he's trying to say.
Well, it depends on what's the basis of the error. If there's a way in which you can say that it was a de minimis error, and you do have a chance for resubmission, but it would, where was the blank, and was the information otherwise available? Those are the types of things that you would need to, that I would need to know. But you can email us at info@challa.com and I can give you some guidance.
All right, the next question is from AA. He's asking, I don't know, he or she, overstay, is it forgiven for asylum application?
Yes, if you're granted asylum.
All right, next one from another AA. My EB2, EB3 downgrade I-140 was received by USCIS on October 12, 2020, approved March 16, 2021. Just yesterday, very good. My 485 APEAD was applied concurrently, which hasn't moved yet. My priority date is February 2014. I'm currently on H-1B. My current employer do not have any plans to revoke my I-140, and they merge with a bigger firm in future. They may merge with a bigger firm in future. They are encouraging us to keep our options open. My question is, what are the options at this point? I have an offer to join another company. Should I just wait for EAD or H-1B?
Well, no, October, November, December, January, February, March, April. At some point in April, you're 6 months on your, whatever the receipt date is on your I-485, it would be pending for 6 months. Then you can port to a new employer, same or similar employment without any issue. You shouldn't port before then, even if the employer doesn't revoke it. If you don't have the present intent, it won't be portable. So after April, you can change depending upon the receipt date. And I would go ahead and file a new H-1B. You want to keep your H valid in case there's some issue with the adjustment down the road.
All right. Pushpak Narayana. Sorry, he says, please ignore the question. But do you think you're the new person? Welcome. Maybe you have a question down coming up. Here's a returned person, Mariangela Basi. Good afternoon. Asking a question on behalf of my son who's in USA. Is it true that a not-for-profit company can obtain an H-1B visa more easily? What are the steps for a not-for-profit company should take in order to apply for an H-1B visa? Thank you.
It's not that they can obtain it easily, and not all not-for-profits, are it just means that they're exempt from the cap, but not all not-for-profits qualify for exemption under the cap. So very specific types of institutions that are exempt. And if you'd like to email us, we can send you a memo on what types of organizations are exempt from the H-1B cap at info@challalaw.com.
All right, Prem Pathak is back. What is the minimum weekly hours required for part-time H-1B?
There are no set hours, but whatever is stated, that's the minimum amount the company has to pay you. So it's better to err on, you can even put a range, but there's no minimum that you have to for concurrent filing.
All right. Anil Vishwanatha it's a new person too, welcome. Is E3 eligible for Dropbox?
Yeah, as long as it has expired, within the past, I think they've expanded it a few years, and you are getting the E3 at the same consulate that you got it originally, yes. Same country.
Next one is from an AA. I overstayed my, I think he wants to say H-1B because it doesn't say H visa by 4 years. Can I renew it? I don't know, it's H1 or L1. B, there's a one, L, like a lowercase L1 and B. By 4 years, can I renew it?
Not if you were not on any other status in the US.
All right. Then Daryl Mulder, welcome. If my B1 is pending and I have E3 in premium processing, will my B1 need to be approved first? And how long could that take?
So do you mean you have a B1 extension? So if you've got a B1 extension, usually if you file that first, they usually like to see the underlying petition approved. But another thing you could do is do E3 premium processing for consular processing, and then go to Mexico and process your E3. Or go directly to Mexico and process your E3. Because remember, you can process E3s at the consulate.
All right. Daryl, if you like, you can send an email to info@challalaw with more details or respond to her question, and then we're glad to send you a detailed response. Thank you. Next one is from AA. If you switch employees on an EAD, does the employer file the I-485J or does the employee? What happens if 485J gets declined? Are you illegally working and are out of status and it doesn't, and it does it destroy your I-485 application?
First, remember, you can only port to a new employer after your I-140 is approved, 180 days, your adjustment's pending, into same or similar employment, number one. Number two, both the employer and the employee signed off on the I-485J. And finally, there should be no reason why the I-485J is denied. Unless it's not signed correctly, so that shouldn't be an issue.
Okay. Vijay Talapragada is back. His question, Has anything changed since the new administration took oath on prevailing wage requirements? Internally, we are facing some difficulty in reviewing visas as wage requirements in some cases will require us to increase base pay by 32%.
Right. So what you can do, and you can, I'm happy to set up a time to talk to you about what your company can do to address this. The new wages won't take effect till May. So you can file LCAs now between now and May, and it won't be subject to the new wage rule. And so if I'm going to be hiring, and not only for your existing employees for extensions, but even if you're thinking of, oh, down the road, I may need, I've got this big project with Anthem in some place, and I may need 3 or 4 software developers there. You don't know who they are, but you may sponsor them for an H-1B. You can file those LCAs now, and it won't be subject to it. So email us, and I'd be happy to talk to you about other strategies before the new wage rule gets implemented.
Okay. Another AA is asking, how long does the I-485J take to get approved once you switch employers on an EAD?
It just depends if your date is current. Usually, back in the day, it would take about 60 days. But I know, like I said, the new administration is going through this transition. A lot of people that were there at USCIS are leaving. So not sure what the current processing time would be.
All right, Sri Kumar is back. My final action date is current. Got receipts for my EAD more than 90 days ago. I'm still waiting for biometrics. I see people getting biometrics who applied much later than me and whose data is still far away from being current. Is there any pattern for biometrics? What factors are considered? Yeah,
what you should do is look back at our webinar that was 3 weeks ago. We have on there links like phone numbers, what you can do to call to get your thing expedited, and how you can alert them to, maybe it was just overlooked. You should have gotten your biometrics by now. But like I said, it was about 3 weeks ago. It's on YouTube, and it has all the email addresses, phone numbers, and the process that you need to take to get it to the USCIS's attention.
Vijay, welcome. Thank you. Vijay says thank you. So welcome. Next one is from an AA. Hi. H1 expired March 9th. I have applied for H4, applied this March 10th. While I'm waiting for my perm, applied August 2020. What would be right option to wait for? Is it wise to go to offshore to get H4 stamped? Will US Embassy be available next couple of months, or wait until perm I-140 H1?
If you must travel, we had a show last week on processing in Mexico, and there's a contact. There's a company that actually helps people get visas in Mexico. So take a look at last week's webinar, and it has the contact details. You can contact them and see whether you could process your H4 in Mexico under emergency or the national interest provisions.
Okay.
And remember, the ban is lifted March 31st. So I haven't heard that they're going to extend it. So, in that case, you could travel home and it wouldn't be a problem.
So please look on the chat. Our team is posting the links of the webinars we had. One on the third country stamping, that is the one last week, and the one before the USCIS webinar recording, contacting USCIS. with all the phone numbers and all that. So
There is one thing that alarmed me about that question. He said he expired on the 9th and he filed
on the 10th.
Yeah. Why didn't you file prior to your expiration? And if you did that, then you do want to go overseas and process your H as quickly as possible, because only when you file your extension or change of status prior to the expiration do you have are you in a stay authorized by the Attorney General. If not, then that means you're you could be unlawfully present. So you don't want that to exceed 180 days. So I would recommend that you go overseas and process your H4 because it would be quicker.
All right, another AA is asking, I completed classes at college while out status. Am I eligible for work authorization, example OPT?
No.
Am I out of status? I'm out of status. Can I apply for diversity visa? Came here legally.
Yeah, they asked that question before. We've already answered it.
Can I get work authorization if I marry a green card holder?
No, because green card holders are not current. And if you're out of status, the only, if you entered legally, but you're an overstay, you have to marry a U.S. citizen in order to, kind of wash your overstay, and only U.S. citizens can do that and get work authorization immediately because there's no backlog. There is no quota for U.S. citizens.
All right. How much time do you have?
Until 1.
1. So I got quite a few questions, ladies and gentlemen. So we'll just answer these questions that I have. The last question I have on my list is from Sridhar Chanda. So appreciate if you could just send an email to info@challalaw with your questions, and we'll be glad to respond.
And that's why I said at the beginning that if you have asked one question, just as a courtesy to the other people who are attending, don't ask another one, so we can get to everyone's questions. Instead of.
Or, if you just put everything in one, that also will help. We're just trying to make sure we cater to many people in the session. But you're always welcome to email. That's not an issue at all. All right, let's go to Dinesh Sriram. I think is a new person too. Welcome. I have filed E3 visa extension in November 2020 with my old client. I have changed in the client in December 2020 after filing, and I haven't updated to USCIS. Now I have a specialty occupation RFE for extension filed in November 2020 for old client. Should I have docs ready for RFE based on old client or new client?
Well, if it's specialty occupation, it wouldn't matter whether it's old client or new client. And I don't know who your attorney is, but there are some really good court cases and issues to overcome that. If you want to send us the details, I can take a look at your case and tell you how you should proceed.
He's got some more questions. Or should I have docs ready for RFE? Okay. And also, should I update them now, telling the same? New LCA is now initiated on work from home location from our previous email conversation. And thanks for providing the information. So Dinesh just sent an email, and she'll clarify, I think it just makes sense to put together a nice email, and we'll get you a good answer, a quick answer too. Next one is from an AA. I-539 COS from L1 to H4 was rejected by lockbox, stating that wrong form was submitted. I-129 was suggested to be filed instead in the rejected notice. Attorney refiled, mentioning that the rejection by lockbox was an error. Would the earlier receipt date be retained if USCIS accepts that rejection was indeed an error. H4 EAD that was filed concurrently was accepted though.
He changed from what? He changed from,
L1 to H4.
okay, so L1 to H4 should be an I-539. If they ask for an I-129 and they did it in error, what your attorney should request when they're resubmitting is they ask it for nunc pro tunc. That means you want, because it was an error, they should accept it as the date it was originally filed. But the attorney has to request that.
Okay, what's that term? Maybe the team can put it in the chat.
Nunc pro tunc. They just have to say, if they don't want to use the Latin term, they can just say, we want you to preserve the previous receipt date originally because it was rejected in error.
Okay, it's there on the chat, gentleman or lady, whoever is asking the question. So you can just copy and paste that. All right, let's go to Naveen K. Follow up on my LCA question, filing before 6 months. What could be the reason to not get full 3 years if we file LCA before 6 months compared to when we file an LCA within the 6 months window?
Because you can only request 3 years on an LCA. So think about it just from a mathematics perspective, okay? If you're filing an LCA in April 1st, right? So you can ask for April 1st, 2021 to April 1st, 3 years from now, 24. And, but, your H-1B is going to expire in June, right? Or expire in November. Let's say it's going to expire in November. You would be eligible if you still had 3 years left from November 2021 to November 2024. But you can only ask for the validity dates that are on your LCA. And your LCA is going to expire April 2024. So it would be shorter. You're still eligible to file another extension, but that's just the way, the functionality of the LCA.
Okay. Another AA's question, how much money should I invest in US company to be eligible for green card?
Oh, that's for the EB-5. Well, it depends on whether it's in a rural area or whether it's in a city. If it's in a targeted employment area, it's $950. If it is in a city, I think it's, what is it, Shaker, 1.2?
1.8, 900 and 1.8. 900,000 for a regional center, 1.8 for a metro area. So if you send an email, I can give you more information. I've got some projects to info@Challa Law, and you can just say in the subject line, EB-5 visa. So
We've got some charts and stuff, also resources that we can send you.
All right. Next one, I still haven't received my 485J receipt, although I did receive all of the receipts. Got fingerprinting appointment too. What could be the reason not getting 485J receipt?
There is a delay in 485J receipts across the board. So you're not, it's not unique to you. For some reason, there's a delay in issuing those receipt notices. It's a few weeks, several weeks after you get your other receipt notices. So just stay on the lookout and I wouldn't worry.
All right. DEM, I think must be Dinesh, probably had I-94 day. That's all you have. So just send us an email with more details, and we're glad to send you a response. Vijay Talapragada has another question. From a talent attraction and retention perspective, how would you advise companies on who pay for immigration fees and to what extent? That is, should we pay only for employee and not pay for their families?
That is different for each company. There are a lot of companies that don't, even bigger companies that don't pay for family members. From a talent retention perspective, one way in which you can attract more people to join you is you can go ahead and have prevailing wages and have all the preliminary steps of a perm always in place. So when somebody joins you, you can say, within a month, I'll be able to file a perm on your behalf. That's something that's, probably more powerful in retaining or attracting than others.
Okay. Next question is from the AA. When are you going webinars about asylum?
I don't do, we do employment-based, we do family-based. I don't do asylums. I have in the past, I've done them pro bono, but it's not something that is part of our bread and butter. It's not something that we do on a normal basis. So I won't be having an asylum webinar. Sorry.
Yeah, may have to look for another, resource.
And I think
anything
we have.
else
We've been referring them out to actually an attorney that worked for me years ago. He's really very good. And so.
Okay. Sounds good. Last one, Sridhar Chanda. My I-480, my I-140, 485, 76, I-30, 131, whole packet were rejected due to incorrect fees. We submitted $700, $1,225 checks along with documents, and attorney had shared me the complete copy of all packet before sending. We are 100% sure the checks were properly sent. What are the options left with me now?
I think we answered that question.
Yeah, it must be we answered it with the AA probably, and then now this is Sridhar. Sridhar, we answered this, but if you like, just send an email and we'll be glad to, send a response again, proper with any extra information or links.
Yeah, because I'd like to see a copy of the checks that were sent. So if you email us, send me a copy of the checks that were sent.
So many times, when they say incorrect, rejected due to incorrect fees, there are a couple of options, just there may be, it's like how, we have default values in a database for certain fields. And if you don't put all the default values, you just pick one value that you think is correct, but then that's bad management, database management, right? So incorrect fees, it could be, that's my experience. Maybe the date is wrong. You did not forget, you did not sign the check, you or whoever, So it could be any one of those, not necessarily the amount. It could be some of the other thing as far as the check is concerned. And they did not have any other, they didn't care. I mean, when it say the USCIS, whoever, rejected, incorrect fees. But when you open the check, what it is, you sign it, the date was correct, or whatever, see what I'm saying? So just expose, so send a copy of the check. She'll be glad to look at it and let you know. Last question, I think, is a good one. Roma Kinjale, sorry. Can you do a family-based webinar? Would like to understand the process and categories.
Sure, we'd be happy to. I love the suggestion. So we probably won't do that as part of our weekly webinars, but we're doing special webinars, and we'll make sure that we let all of you know about that family-based. And I think you can have a special webinar even in your weekly webinars. But yes, we will do that.
That's it for today.
Well, thank you so much. We want to thank my team, Kara, Mac, who are on the call, but especially Kara for the hard work she puts in getting all the information out on the chat, putting all this together. Thank you, Shaker, for your moderating. That it's really very helpful. Everybody have a happy St. Patty's Day. Stay safe.
Yeah, I just wanted to pass on, I think earlier we had sent intimation saying that our website was temporarily down. Now it is back.
Oh, good.
Any browser, it is back. So just wanted to pass that on. Thank you, Lakshmi. Happy St. Patrick's Day and St. Patrick's Day. See you
Stay
later.
safe. I look forward to seeing you again next week for our weekly webinar. And if you found this helpful, please share our webinar details with your friends. And look forward to seeing you again next week. Thanks.